Appeal in the matter of Theis and KR children.
Yes, Miss Kirby, have you negotiated a little extra time?
We have, my lady. I think the highest that Mr. Jarman was willing to go was 7.5, but I think he meant 10.
He's all heart.
Time starts now.
Yes. My lady, just dealing firstly with the point that your ladyship raised late yesterday, that I obviously didn't have time to deal with, which was the domestic abuse that was in the background as alleged, and that Mrs. Justice Theis had taken as at its highest in the way that she's supposed to. And I just wanted to remind your ladyship of how she dealt with that in the first judgment in the judgment was in February, but the hearing was in January, and you find that in the supplemental bundle, 136, 131. That's where the judgment starts, but the 128 is where she deals with protective measures.
Could we use paragraph numbers, please?
Certainly. The judgment starts 126, and then the first paragraph that I'm not going to wait for you to read it, but paragraph 22, 23, and 24 deal with X's report of DV to Miss Callahan in January.
Yes, thank you.
And then, as I set out yesterday, that was very similar in substance to what she later told Miss Broadley. Then the protective measures are dealt with by Mrs. Justice Theis, starting from paragraph 31. She sets out there the raft of protective measures that she found in January would be sufficient to keep X and Y and the mother safe if she ordered a return, which she did at that time. And then in the same judgment, she deals with discretion, her exercise of discretion, from paragraph 40. And she sets out very carefully the 6 factors leading to her exercising her discretion in favour of a return. So what the father was saying at the rehearing was that there was no change in substance between that exercise of discretion with the same background facts and her next exercise of discretion, where we say she went wrong for the reasons I set out yesterday, which was she allowed Miss Broadley's evidence to overtake Miss Callahan's evidence in terms of strength of X's feelings and how they had changed. And what it's very important to remember, and it's a point that's made on behalf of the respondents in this case, that we didn't call Miss Broadley to give evidence, and we didn't call Miss Hawkins to give evidence. We didn't do that because it was a summary proceedings. There were no findings of fact going to be made as far as we were expecting. And under no circumstances did we think that Kafkas would be displaced in favour of Miss Broadley's evidence. So we didn't cross-examine, for example, on all of the opinion evidence that I took you to yesterday that Miss Broadley had expressed in her statements. And we certainly didn't expect Mrs. Justice Theis to put into her judgment all of those expressions of opinion and then to accept them. And she says that she accepts them. For example, and the most important thing that she accepts is Miss Broadley's assessment that X's views were authentically her own and that she hadn't been influenced by her mother. Under no circumstances could we have expected an experienced High Court judge to accept that and to replace the expert opinion that she had accepted in January from Miss Callahan.
The letter that you took us to yesterday, though, Kafkas seemed to be content to rely on Miss Broadley as a person who was going to be able to present the child's views.
Well, my lady, the person, Miss Doyle, who spoke with Miss Baker on that day, she wasn't the case officer, and it's not up to them whether they're willing to rely on Miss Broadley or not, and they hadn't seen what Miss Broadley was saying. So they were speaking from an uninformed point of view, and said so. Miss Doyle clearly says, I don't know what the details are, but this is what I can't see immediately what we can help with, but if you do want our help, these are the kinds of areas we could help with. And one of them was the authenticity of the views. She cautions the usual, it's not good to see the child again if it's unnecessary and if it's properly being represented separately. But at that time, she sets out that menu that they could help with, and she says we could do it by the scheduled rehearing. So, but the turning point for Mrs. Justice Theis that day was the fact that the father was saying, I won't seek to separate. So as a matter of logic, when he changed his position to, I do seek to separate, if the court allows X's feelings to reign, then the logical next step was that Mrs. Justice Theis should have allowed Kafka on separation, if nothing else. Because at stake, as I said, for the 5-year-old, was the fact that he was losing, had lost, and was about to completely lose his relationship with his father. And that's not a step that should be taken on a summary basis, and it's certainly not a step that should be taken on the basis of an advocate solicitor's views of what her client is telling her, when she wasn't there in January, she doesn't know, and she's not qualified to assess how authentic and how real and what a change there had been. The only person who could compare January to March was, May by the time we got to that hearing, was Miss Callaghan as the expert. But if you then look...
Can you remind me what submissions were made as to Miss Broadley's evidence? Was it submitted that it was inadmissible?
No.
Was it... So what submission was made? That it was evidence that the judge had, and you seem to be submitting that the judge should not have taken it into account.
Not that she was perfectly entitled to and should take into account the straight description of what was being said by X, as reported by Miss Broadley. She was perfectly entitled to take that into account. But she went further than that. She accepted Miss Broadley's assessment of whether those views were...
Was a submission made to her that was not admissible evidence?
No.
Right. So it was evidence that she had to take into account. Because if it's admissible, she has to take into account.
Well, my lord, this is the point that I made yesterday, and it's interesting that it's Mr. Dias King's counsel who comes in as a non-family practitioner and appears to be appalled by...
Well, can we put that to one side at the moment? Is it admissible evidence? And your submission was not that it was not admissible. So if it's admissible, the court has to take it into account.
The statements, no objection was taken to those. They were admissible. But the contents of the statements, parts of it were admissible, where it's factual. What's not admissible, and Mrs. Justice Theis relied on it, were all of the opinions and the descriptions.
Right, and was the submission made to her that was evidence she should not take into account?
Yes, well, the submission was made that Kafkas are the only people who can tell you anything about whether or not these wishes are true wishes, whether they have been influenced by others. And that Miss Broadley's statement, I didn't go through it bit by bit, but what the main thrust of our submission was that the substance hadn't changed as between January and May, and that was why the court should be going back to Miss Callaghan. And the court had chosen not to go back to Miss Callaghan, but therefore the obvious next step is that the judge has to keep what she has of Callaghan and exclude what she can't rely on from Miss Broadley. Specifically, the issue of opinion evidence, I didn't address the court on. But in the family court, we have opinion evidence spread throughout our statements. But
well, what I'm trying to understand is the framework within which the judge was considering the evidence. And if it wasn't submitted to her that it wasn't admissible, if it wasn't submitted to her that she couldn't take into account what we're describing as opinion evidence, then what was she supposed to do? Take it into account?
Well, my lord, it's a very basic rule of evidence that the only people who are allowed to give opinions in court are experts.
Is it? Is that a very basic rule?
Well, my lord, opinion evidence is
But it depends on what you mean by opinion evidence. Saying the child appears genuine to me, is that not what happens when a solicitor is deciding whether or not he or she can take instructions from a client, from a child?
My lord,
the child is competent.
in terms of competence.
So
There is an
opinion,
element of that,
right.
yes. But as I think my lord dealt with in speaking with Mr. Gratian yesterday, there is a point where at the beginning.
So your submission now is that evidence from a solicitor as to the, for want of a better word, credibility of a child's views, or the what's motivated the child to express the views he or she is expressing, is not a matter on which evidence from a solicitor guardian is admissible.
My lord, the submission is that where Miss Broadley or a solicitor strays into coaching, for example, authenticity, those are not areas properly of an advocate or of a solicitor who is not qualified to form those views. Those are properly the province of Kafkas or a social worker. And that's what Miss Doyle was saying Kafkas could help the court with, was authenticity. And instead what happened here is that in new circumstances, i.e. after a return order was made, there was no reverting to the proper place to get that evidence, the child-focused objective evidence, and instead Miss Broadley's evidence overtook the
Can I
January
just check
evidence.
in? Are you saying it's inadmissible or it's admissible?
Opinion evidence from a solicitor about a child matter is inadmissible. It must be. They're not experts. And the only way that the court can have opinion evidence is under Part 25, where you get somebody with a CV that's properly qualified to give the expert evidence. And no solicitor, unless they're dual qualified as a social worker, can
Very
profess
broad
to have.
submission. Opinion evidence by a solicitor about a child matter. It's inadmissible.
Well, about specifically, if I don't make it that broad, specifically about authenticity of a child's views in this context and whether there's been coaching. Because the case that Mrs. Justice Theis accepted based on the evidence of Miss Broadley and the mother in particular was that she accepted their evidence, which was how she was presenting how she felt, how she had been affected by the decision to return. And it was very much at odds and much stronger than it had been in January when the objective expert had assessed the same child.
May I just ask a question, please, Ms. Kirby? Did you submit to the judge that the evidence of the solicitor should be given less weight or considerably less weight than the evidence of Kafkas?
I think I'd have to check that.
Well, it's
my
quite
lady.
important because even if you didn't submit, make a submission about inadmissibility to the judge, it might be useful for us to know whether you made any submission about the weight that should be given to the evidence.
I would certainly check that. I know that I certainly submitted that the judge couldn't prefer Miss Broadley to Miss Callahan's evidence on the wishes and feelings. But specifically weight, I will check the note.
Perhaps I can help. I've just been looking at your lengthy position statement for the rehearing. And what you say at paragraph 4, page 44 of the supplementary bundle is the only thing that has changed is that the court is aware, thanks to the intense involvement of Amelia with with the child, with Miss Broadley, and Miss Broadley's comprehensive statements, just how strongly she wants to remain in England, does not want to see her father. So and there's other threads through. I haven't had a chance to look at it.
What page was that?
That's page 44 of the supplementary bundle. And then at paragraph 22, the court's invited to treat with great caution the submissions made on behalf of a 12-year-old with the above set of experience. So my reading, and I'll obviously read your position statement in more detail, Ms. Kirby, is that the position at trial was that the content of Miss Broadley's statement was accepted, and that the position taken on behalf of the father was actually, but it's no different. You're just, the exercise of your discretion should be no different, because actually what you say is what has changed. I think the unfortunate word the child is regarded as being in a frenzy. I don't know where on earth that's come from as a piece of, but it suggested that the mother was responsible for the child now presenting as she was doing, but it was not. It seemed to be accepted that how Miss Broadley put it was how it was.
Well, the word frenzy comes from Miss Broadley saying that it was the distress was growing day by day, but that didn't deal with why that was happening.
So it was your word, frenzy. You were describing the child as being in a frenzy.
No, I don't.
Sorry, the word frenzy is in your position statement, and I just wasn't sure where that description of the child had come from.
It may well be my word, yes, but in terms of its provenance, it was the description by Miss Broadley of the distress growing day by day. I wasn't in a position to say whether X was growing distressed, but what we didn't know and what we were saying should be investigated was why that was happening and whether the mother was behind it, and whether, as the mother had made X act in.
I'm sorry, but I'm not being clear. I raised that simply in response to my Lord Justice Moylan and my Lady Justice Laing's asking you how the case was put at first instance.
Yes,
and I thought it might be of use to draw on your position statement.
Thank you. I think that's taken from the skeleton argument, but the position statement I will check, and I'll come back to it later this afternoon when I found the reference to how we put it in terms of not relying on Miss Broadley and relying on.
I think you'll struggle to find anything.
Well, I will look, my lady.
But I'd be grateful if you would, thank you.
Yes, I will.
If you could, Junior, one of you could, that would
Yes.
be very helpful.
But my point, my lady, about the opinion evidence is that in family cases, Mr. Turner, King's Counsel, pointed out yesterday, there are opinions in all of our statements, and that is not supposed to happen, but it does. But what judges do is they form their own opinions and put to one side the opinions of witnesses, lay witnesses, and for these purposes, Miss Broadley is to be treated as a lay witness rather than an expert witness. That's the point.
I know we've been asking questions, but you're now nearly 25 minutes in.
Yes, sorry, I will sit down and wait.
You'll have another opportunity in reply.
Thank you.
Thank you. Yes, Mr. John.
Thank you, my lady. My lady, can I begin by firstly, again, extending our thanks to the court and to Lord Justice Moylan in particular for allowing us extended time to submit our submissions, which allow the proper presentation of this case, acting for the mother as we do on a pro bono basis. I just wanted to briefly go through the context of the orders that were made prior to the hearing in May to give the court an understanding of exactly what was being argued at the hearing before Mrs. Justice Theis in May, making the point, of course, as we do, that this judge was the continuity judge throughout not only the three main judgments she gave in February, March and in May, but also dealing with substantive directions and case management issues throughout the progression of this case. In February, after a two-day hearing, Mrs. Justice Theis determined the children returned to Mauritius in the way that is set out in her judgment, and at that point, the only issues before the court was not that X objected, because that was accepted by both the mother and the father. The issue at large at the court then, in January, February, was Article 13b and the exercise of the court's discretion. Far from influencing X, the complaint made against my client, is that she didn't properly explain the decision in February to X, and that she was unable to understand the consequences or timeline of the decision to return to Mauritius in the way that the judge had set out. A learned friend for the appellant makes the point or seeks to criticise my client for X being involved in the proceedings and knowing about the adult issues. Well, that's rather highlighted by the Kafkas report at page 138, paragraph 26 and 27 of your supplementary bundle, of the core bundle, sorry, where inevitably this child had been subject to the separation of her parents for 2 years prior.
Sorry, what page was that again?
It's page 138 of your bundle, Kafkas report of Miss Cole Fitzpatrick. Yeah. Forgive me. I think yes, it's 138 of your bundle.
Which paragraphs?
Paragraph 27.
Thank you.
26 and 27. She's not being shielded away from the parental dispute. She's very aware of the proceedings. Well, of course she was aware of the proceedings because she was being interviewed by a Kafkas officer of the High Court team. And her objections were noted, her wishes and feelings were noted, and the father accepted that she objected to a return to Mauritius. Ms. Fitzpatrick at paragraph 27 makes the point that whilst her views are aligned to those of her mother, I consider her views to be authentic. And that's the steer that the judge took in February. Now, if I can direct you to the supplementary bundle, and in particular, page 142 of your bundle.
142.
142.
Thank you.
This is the order of the 16th of March. This hearing was convened shortly after Miss Broadley had applied to the court for disclosure of the papers. There was a previous hearing earlier in March, and this matter was listed on notice to all parties to consider the joinder of the child and to consider the set-aside application, making the point that in this case, at trial, Mr. Netto, who has been removed to the substitutes bench, but he was, of course, the solicitor for the appellant. And so he, of all people, was acutely aware of the issues in relation to solicitor guardians. And he was acutely aware of the evidence which Miss Broadley had already put before the court, because both her statements dated in early April, and the 15th of April, the day before this hearing, were already before the court. No issue was taken with the joinder of the child, and that's at paragraph 2 on page 142, by either the mother or the father. The court repeated its invitation to the parties to consider their positions in relation to the children and to understand where these children were, paragraph 4 of the recitals. And then the matter was set down for a hearing on the 4th of April, paragraph 11 at page 144, 4th of April, but in anticipation and as a precaution, if the court did set aside the order, it listed it for a final hearing in May. So all of those perfectly sensible directions at which the father was represented and all parties considered the particular issues. At paragraph 4, I simply again draw your attention to page 143. In the event the set-aside, the last sentence of paragraph 4, in the event the set-aside application is successful, the court invited the parties to consider carefully what additional directions might be sought. So everybody was on notice as to what might happen at the listed hearing on the 4th of April. That was some 3 weeks hence, and the final hearing was listed for some 7 weeks later on the 4th, 5th of May. We then get to the 4th of April, and that's at page 164 of your bundle. And at this hearing, the judge set aside her previous order. All parties at that hearing represented by leading and junior counsel. Paragraph 7, the court again encouraged the parties to reflect on the situation of the children. But the important paragraph is paragraph 8. The father does not seek to separate the children. In the event, the court determines that X should not be returned to Mauritius pursuant to the convention. In light of the father's position, the court determined that an addendum Kafkas report was not necessary for the purpose of the rehearing. Now, it's not right to say that the parties, by omission, forgot to allow for an addendum or failed to notify Ms. Fitzpatrick that should be required to give evidence at the final hearing. It was never part of our case that there should either be an addendum or that we required Kafkas to give further evidence. It's also not right to say that the mother was seeking to put X in the middle of the court proceedings during the course of the final hearing or indeed the hearing on the 4th of April. X attended with her paternal aunt. She did not attend in the company of her mother, and the mother's evidence before the court was that there had been a significant deterioration in the relationship between her and X. And as you've seen from the evidence of Miss Broadley, relied upon by the court, X felt that the mother was unable to protect her, and she'd taken on a protective role in relation to her brother Y. So what we had said to the court was, X is an articulate and intelligent child, who at that stage was 12. She had been concerned that her case had not been properly pleaded, and it was a matter for her team and her guardian as to whether she herself should be present in court. Mrs. Justice Theis invited the trial's team to consider their position, and they reflected upon that and determined that X would not be present and that she would be returned to school. The order was therefore set aside, and that order further reflects at paragraph 3, and the numbers have gone a bit awry in the actual document. So if we look at page 165, although it's paragraph 3, it should be paragraph 15, I think. But the direction to the father's solicitors to notify the other parties and the clerk to Mrs. Justice Theis by the 28th of April as to, there's a mistake there, as to which witnesses effectively, if any, they'd be seeking the court's permission for oral evidence. Now, that was over 3 weeks from the 4th of April. The father appealed. That did not stay this order. And it's clear, therefore, that it was still within the gift of the father's team to notify the parties and the court as to whether they wished to challenge the evidence of Miss Broadley, make those points which are now being made about admissibility and weight and opinion evidence, and or ask Miss Fitzpatrick to attend in any event to be asked questions. None of that happened. And the court clearly identified at paragraph 9, just going back one page, paragraph 9 over the page, the issues which were going to be determined at the final hearing on the 4th and 5th of May. So I repeat, there was no omission on this side of the court as to the attendance of Miss Fitzpatrick, or indeed in relation to an addendum report. We then, please turn back to the core bundle, we then have the judgment of Mrs. Justice Theis, and there's a clear chronology set out by the judge at page 110 of that bundle. And she returns to her previous judgments and sets out the clear understanding as to how the set-aside came. And it's worth reflecting, of course, that in the judgment of the set-aside in April, the court had been clear that there had been a fundamental change in circumstances. And so, with respect to Moylan and Friends' arguments, she and her team were on notice that the court had relied upon the evidence of Miss Broadley to determine, in the first instance, that there should be a set-aside in any event. But the father's position is set out at paragraph 26, where Mrs. Justice Theis reflects 4 lines down that the father considers that X's wishes have hardened due to the outcome of the earlier hearing. She also reflected...
Sorry, which paragraph are you doing?
Paragraph 26 on page 110.
Oh, thank you.
4 lines down. She also reflected at the bottom of that paragraph, father denies the allegations of abusive behaviour, although recognises that X was present during arguments between her parents, which he places responsibility for on the mother. The court further reflected that exercising its discretion, which was at large, that not only the evidence of Miss Broadley, but also that of the mother, and that's set out at paragraph 27 over the page, about the description of the mother in relation to X's relationship with her, and the deterioration of that relationship since X had found out about the return order and the concern of the head teacher in her presentation to the school. Paragraph 30 at page 111, the court reflected that despite the father's appeal, the Court of Appeal itself, at the bottom of paragraph 30, the Court of Appeal itself had reminded the father's team that unless and until a stay is granted, it should be assumed the hearing next week is going ahead. So there was no reason for the father's team to ignore the direction of Mrs. Justice Theis in April to notify the parties in the court of oral evidence, and of course that order had never been stayed. So the court had a variety of different aspects of evidence: its judgment, the Kafkas evidence, the parents' evidence, Miss Broadley's evidence, the head teacher's evidence, and its own dealings with the case since January. And all of those aspects fed into the judge's discretion, which was at large. At paragraph 63, the court makes clear, page 119 of your bundle, the court makes clear that the father did not, or the father accepted that X objected. So there was no arguments about influence, there were no arguments about the fact of the objections. That left the court's discretion at large. There was never any challenge to the evidence in terms of a request for oral evidence. There was never any assertion, either in April or in May, that the guardian's evidence was either inadmissible or indeed, as Lady Justice King has just identified, any arguments as to the weight to be attached to the evidence of Miss Broadley as opposed to that of Miss Cole-Fitzpatrick. And at the bottom of, the court then went on to consider the various aspects of the case being put to it. At page 118 of your bundle, paragraph 60, is the reference to the word frenzy, where the court is summing up the case on behalf of Miss Kirby.
Sorry, what paragraph?
So it's paragraph 60 on page 118, at the bottom of the page. It's almost the last line of that paragraph.
Oh, sorry. Back.
So discretion at large, and the court then considered its discretion, set out that in very clear terms at paragraph 64 onwards, page 119 of your bundle. And in particular, the judge identified all the relevant factors in our submission in the exercise of her discretion. It's a very clear and detailed judgment. And she makes reference in terms to the influence of X by her mother at subparagraph 2 on page 119, and makes the point that whilst I can't rule out X being influenced by her mother's position, I accept the evidence of Miss H and Miss Broadley regarding the level of X's distress they have witnessed. That's not, we say, opinion evidence, that's factual evidence. That's the presentation of this child to her school and to the solicitor. X has remained resolute she will not return to Mauritius. The detailed account given to Miss Broadley in her statement is balanced and compelling. The learned judge also then considers the points raised by Miss Kirby at subparagraph 3, and importantly, the issues in relation to the policy of the convention at paragraph 7 and 8. And of course, noting that this very same judge had already made a determination this child should be returned in January, February, in accordance with the policy of the convention. So the judge then also went on to consider the exercise of the discretion in relation to X and Y, the younger sibling, and that's at paragraph 69 on page 122 of your bundle. And the father's volte-face on the night before the final hearing in relation to separation of the children. And that's set out at subparagraph 5 at the bottom of page 122. Not sharing the father's confidence that effectively, having accepted that X objects, having gone through the exercise of discretion, having determined that X should not be returned to Mauritius, but then effectively undermining that decision by returning Y to Mauritius in the expectation that X and the mother would simply return. And as the learned judge makes clear, that course is simply counterintuitive to the determination and the independent determination of X's wishes and feelings and her objections to return. And Mrs. Justice Theis emphasises at subparagraph 6 the limitations of this summary process, which we all had in mind throughout. So we say, in terms, that this is a moral judgment. This judge was not directed to any of the submissions that are now being put before you as to weight, admissibility, opinion evidence. No point was taken about oral evidence in relation to either Miss Broadley or Miss Fitzpatrick. And in those circumstances, we rhetorically ask, what was the judge supposed to do in those circumstances? The discretion is the discretion of the trial judge. That she has clearly and in a very detailed way set out the reasons why she exercised her discretion. And we say that in those circumstances, this is an impeccable judgment by a very senior, experienced High Court judge of the division. And in those circumstances, we say that this court should dismiss the appeal. The court will be aware in our skeleton argument we have made reference to Reed TG, page 75, paragraph 25 of the bundle. It appears that Reed TG did not make it into the bundle. I have hard copies of that, which we'll hand up to the court in due course, but we set out the summary in relation to appealing case management decisions, and we say effectively this is a appeal against certain case management decisions which were not followed through to the final hearing, and the judge in those circumstances can't be criticised. So, my ladies, my lord, those are our submissions in relation to the appeal. Unless there's anything in particular I can assist you with the appeal, I'll very briefly deal with other aspects of the principle of children. Children in Hague, 1980 Hague Convention proceedings arise in only two ways, as the court would be very familiar. One is Article 12 settlement defences, and the other is Article 13(2), child's objections. Now, the settlement issue is being determined by Baroness Hale in Re M, which is at tab 9 of your authorities bundle, and in particular paragraph 57 of that judgment, where she set out the circumstances in which children in settlement cases where the policy of the convention can't be complied with should routinely be joined at the outset without causing delay to the case. Child's objections cases have a much more nuanced aspect in respect of joining children to proceedings, and routinely, where the defence is raised, CAFCAS are asked to provide a report as to the wishes and feelings and objections of that child. The objection, of course, is a matter for the court. We say that it's, in fact, a vanishingly small amount of cases where a child will find its way outside the CAFCAS loop to an independent solicitor. But it does happen. It happened in the case before Mr. Justice MacDonald. It happened in both of these cases. And of course, a number of very experienced child law solicitors have been concerned in these type of cases. Miss Broadley, Mr. Nesso in particular in this appeal, but the late Miss Hutchinson, Miss Hanson, Miss Coyle, all names very familiar to this court, all experienced child law solicitors. And I emphasise the point that Mr. Turner made yesterday. They do have an expertise. They are very used to having children as clients. They do not hold themselves out as experts in child law or social workers, but they do have an ability to judge, in their opinion, as to the competence and capacity of a child to give them independent instructions. And by way of example, we direct the court to the case of Re CS, tab 23 of your authorities bundle. And that's the case in which Mr. Justice Williams set out the issues for solicitors instructed by children and the considerations which the court has to take into account when determining whether a child has certain competence. And it's a page, the relevant bit, page 497 of your authorities bundle, paragraph 79. And Mr. Justice Williams sets out the factors which the court has to weigh in the balance in making an evaluation as to whether a child is of sufficient understanding to conduct an appeal in that case, but effectively to instruct a solicitor without a guardian. All of those are nuanced issues which a solicitor has to make a determination about as to whether they're able to represent and take instructions from a child. Whilst in that case, the court very carefully considered what the court felt important, the reality is that in practice, at the door of a very busy applications list, a High Court judge is not going to have time to consider each of those issues of its own motion and determine whether the child has sufficient competence or capacity. It has to rely on the solicitor. It has to rely on the opinion of the solicitor, experienced and with that degree of expertise in child law and experienced in taking instructions from children as to whether that child has sufficient competence. And to that extent, the opinion and the consideration by a solicitor is important and will be relied upon by the court. My lady, my lords, we also make reference in our submission as to the transparency of instructions where an independent solicitor is approached, and the need for transparency both to the court and to both parties, where ordinarily a child would have got to a solicitor through the auspices of the parent in this jurisdiction. But you're going to hear in due course later today from the interveners who have certain submissions in relation to that. So, ladies, my lord, those are our submissions, unless we can assist you further.
Thank you very much indeed,
Thanks.
Mr. John.
Well, my lady, much of the submissions that you've just heard, you'll also find in our skeleton argument, and I don't need to repeat them in my oral submissions. Of course, I represent X. She has her own perspective. She very much wants to stay in this country, as my lady knows, and therefore we urge my ladies, my lord, to dismiss this appeal. That said, I take instructions from X through my instructing solicitor, who is also X's guardian. It is an unusual position for Miss Broadley to find herself in, but she has, as I'll come to in a moment, developed certain expertise in performing, acting in that dual role. It's my respectful submission, or our respectful submission, that X has been fortunate in this case to have had, as a solicitor guardian, someone who has the expertise of Miss Broadley and who has performed her role entirely appropriately in making sure that not only X's view is fully articulated at the hearings after the initial first hearing, but also in this appeal. Miss Broadley's role, the way she carried out her functions, the way that she completed her witness statements containing information directly from X, and also, I accept, her own assessment of what she had observed about X, has never been challenged before these appellate proceedings, was never the subject of challenge in the proceedings below, and has never been the subject of judicial criticism by Mrs. Justice Theis. We make the point in our skeleton, paragraphs 38 to 43, that the appellant is raising new points before this court and query whether the appellant should be permitted to make those points. But there it is, the appellant has made those points, but we very much urge this court to bear that feature very much in mind. It perhaps follows then that it's my submission that if this court feels emboldened or appropriate to give guidance, that is not in any way because of the way that Miss Broadley has conducted herself in these proceedings, or indeed the evidence that she has provided in her two written statements to the High Court. And I would respectfully submit that in fact the way that Miss Broadley has conducted this case comes pretty close to being a model of how, in these difficult situations, a solicitor guardian should act on behalf of a young person such as X. I'll come on to developing some of those points later, but fundamentally, I invite this court to reject the challenge to the case management decision that Mrs. Justice Theis was entirely entitled to make on a very late application to adjourn, when Mrs. Justice Theis had, in my respectful submission, immaculately case managed the proceedings, anyway, since the 3rd of February when X became involved, had given advance warning and had urged all parties to consider carefully the directions that would be needed. And moreover, it won't have been missed by this court, I'm sure, of the way that she timetabled each of the hearings in a pretty concise way from the original hearing in early March, staying the order, through to a further directions hearing, then the set-aside hearing in early April, through to the redetermination in early May. The judgment of Mrs. Justice Theis, which is subject to this appeal, contains in our submission no error of law. She is perfectly entitled to make the findings that she did, applying the law correctly. She was perfectly entitled to exercise her discretion in dismissing the application for a summary return. She was dealing with written evidence and written evidence alone. Primarily, as Mr. Jarman has already indicated, the three sources of written evidence were the mother, headmistress, and Miss Broadley. In the background, because of the role that Miss Callaghan had played in the first set of proceedings, she had the report and indeed the transcript of the oral evidence that had been given at the first hearing. One thing you will not find, of course, in Mrs. Justice Theis's judgment is any recording of submission by Miss Kirby, or indeed any analysis of the wider issues that this court is canvassing, particularly this afternoon, simply because they were never raised. May I take then, my lady, to that judgment in a little bit and go through it in a little bit more detail. The judgment follows an application, very late application, as my lady knows, for an adjournment. That is dealt with in the introductory sections at paragraph 8. We're looking at page 107. Bundle, core bundle. There are then descriptions of the background. Paragraph 20. A recording of the head teacher as well as Miss Broadley's evidence. I'll come on to that evidence in due course in a little bit more detail. My lady, at paragraph 26, a summary of previous findings. Paragraph 27, dealing with the mother's statement about the change or the deterioration in X's position. And at paragraph 30, she goes on to deal with the change of position of the father following the rejection of his challenge to the set-aside decision made in early April, and a recounting of the skeleton arguments and when they were submitted. Paragraph 37 recounts the time very precisely of when the matter returned to court, when the father had made his position clear that he was going to seek an adjournment. Recording at 39 that the unusually perhaps respondents to a Hague Convention were opposing an application for an adjournment. Paragraphs 45 to 46 set out the legal framework, very well known to this court. No reference there to the role of solicitor guardians, or the rules about that, or joinder, or any of the wider issues. My lady, then the submissions are recorded in some detail, starting from paragraph 7. And I'm going to invite this court to focus on Miss Kirby's submissions that start at 57. And my lady will see the way that Mrs. Justice Theis has recorded the way that Miss Kirby put the case on behalf of the father. The court reached the correct decision. This is reading from paragraph 57. The court reached the correct decision on the 3rd of February. The court's judgment need only be amplified in order to make a return order. Ms. Kirby submitted that X's involvement caused further emotional harm, in addition to the wrongful removal. Paragraph 58, the only thing that's changed is how strongly X feels about these matters. She's aligned herself with her mother. She seeks to rerun M's case, but from her perspective, no doubt echoing the words of my Lord or Justice Moylan in B. My lady will see in paragraph 58, or rather will see in paragraph 58, what is not contained as part of Miss Kirby's submission. No attack on Miss Broadley. Paragraph 59 deals with the meat of Miss Kirby's submission, about the exercise of the discretion. Perfectly appropriate submissions there, made no doubt firmly in mind, with having re-M firmly in mind. Again, no attack on Miss Broadley. Paragraph 60. Another key plank in Miss Kirby's case was that it was the mother who was behind X's actions. My lady will know, and I'll come to this in a moment, that is not only not the case from X's perspective, but also not what Mrs. Justice Theis found. And that's Miss Kirby's expression taken from her skeleton argument that the mother had worked X into a frenzy. I don't in any way criticise Miss Kirby for making that submission. I would observe that my lady will not find the word frenzy mentioned by Miss Broadley, or indeed in any other witness statement. But that explains how the case was then being put. Then in paragraph 61, further submissions about disruption of education, which is something that concerned X and is mentioned by Miss Broadley. But you will see in paragraph 61 no attack on Miss Broadley raising that issue, or Miss Broadley being entitled to raise that issue. Again, halfway through that paragraph, the emphasis on the mother's pernicious influence, my word, pernicious. But that appears to have been the way that Miss Kirby put the case. My lady has looked at the skeleton argument. In my respectful submission, that summary in those paragraphs fairly summarises what Miss Kirby was putting in her written skeleton argument, and indeed the subsequent email that came explaining the change in position. You will therefore see that there is no mention of the question of the inadmissibility of any evidence, whether it's expert or otherwise, whether it's assessment, whether it's argument, whether it's advocacy. No question at all of Miss Broadley being cross-examined. No question of Miss Broadley not being appointed guardian, not having the expertise. It wasn't an issue. No reference to questions of privilege, disclosure of case notes, no application for the disclosure of case notes. These issues are all new, my lady. I can deal with the rest of the judgment very quickly, paragraph 62 onwards. In my respectful submission, not only is this judgment impeccable, but it forms a model
of how a court should exercise discretion, having found, or in fact having had it conceded, that X objects. And if I may be so bold, I would go as far as submitting that it would be wrong for this court to contemplate interfering with that discretionary exercise. My lady, can I now move back in time, change tack, to going back to the beginning of X's direct involvement in this case? I hope I can deal with this reasonably quickly, starting at page 178 in the core bundle, which is her plea for assistance, according to the headmistress, to the NSPCC. I know you've been taken to this already. It's not dated, but it plainly must be after the 3rd of February, the date of the handing down of the judgment after the first hearing, and before, we would suggest, the 8th of February, which is when the headmistress first spoke to X. It is something that, in my submission, should be taken at face value. We would respectfully agree with my lady's comments yesterday about a young person of this age having the necessary gumption, skills, tools to Google, find out something for herself. Maybe going back a few pages in the bundle to 173 is the first statement of the headmistress. Just realised I misspoke a few moments ago. It was Tuesday the 7th of February where she first saw X. This statement speaks for itself. Although Miss Broadley did not have this statement when she made her first witness statement, she was aware of what the headmistress was saying. Indeed, it is one of the extraordinary features, that's the word Miss Broadley herself uses, extraordinary features of this case, that X came to come into contact with Miss Broadley, not by her mother, which so often happens, we accept, but via NSPCC school and the head teachers forum. The head teacher is perfectly entitled, in my submission, to give the evidence in written form. I don't think it's been suggested that she lacks the expertise to give the evidence that she gives in this report, in this statement. Just to pick up a few examples, paragraph 6, she started to become visibly distressed, shaking and panicking, eyes rolling with stress, unable to focus. That is factual observation with, if it be an opinion of what the maker of this statement observed. And my ladies and my lord will have in mind what's said in the Civil Evidence Act 1972, which Mr. Turner took the court to yesterday. Of the same vein, over the page, in dealing with the issue of maturity, Mila is an incredibly mature pupil. This is paragraph 12. I would say mature far beyond her years. Over the page, the outpouring of fear she has is immense. X, caught myself in time, X is petrified, going back to Mauritius.
You would say all that is opinion evidence.
Well,
And
I'm not.
but it's not unusual for teachers or others to express views about well, the maturity of a child, or the express views about their perception of what the child is saying.
Well, I suppose there's a spectrum. At one end of the extreme, there would be a diagnosis or medical diagnosis, which
Quite, wouldn't
obviously
be qualified.
is expert.
Yeah.
But then there's a blurring somewhere in the middle between what might be said to be opinion based on other matters of expertise, other experiences, other facts, other skills on the one hand, and then simply expressing an opinion based on observed facts or observed impressions, observed perceptions. So my primary point is that no one objected to any of this in the court below. But dealing with the wider issue, we don't depart from what was submitted by Mr. Turner and indeed by Mr. Jarman, that certain evidence, and one has to really look at it on a sort of case by case, fact by fact, example by example basis, is perfectly permissible to be given by a solicitor guardian. If there is a dispute about that, which there wasn't in this case, if there is a dispute about that, it would be perfectly open for a party to raise the matter, either at a listed hearing or even to arrange an urgent hearing to deal with questions as to whether a solicitor guardian has gone too far or has not appropriately heeded the words of caution of Mr. Justice MacDonald in the Ciccone case. If it's thought that the line has been transgressed as to the one calls it opinion evidence.
No, I understand. I mean, there are a number of points. One is what is legally permissible. If you look at, is it admissible? Is it not admissible? And the other is, particularly in this, as you say, picking up what Mr. Justice MacDonald said, is it sensible, or is it wise? Is it appropriate? I can't think of quite what the word. I can't remember what he.
Well, I
can't remember what he used. Did he say caution?
Yeah, I think the need for caution.
Yes.
I'm sure if someone got the exact phrase, I can look it up in a moment. Maybe
yes.
Leonard Junior can just check the exact phrase that he used. My Lord, with respect, was right yesterday, but Mr. Justice MacDonald doesn't ban it in any sense. Doesn't say it's inadmissible for the solicitor guardian to give that sort of evidence. If it's simply based on an opinion based on factual observation, or even perhaps more contentious matters, whether there's a qualitative difference in the strength of objection, which was an issue in this case, and even more pertinently, questions of genuineness, questions of authenticity. I submit that Miss Broadley, and indeed any solicitor guardian, is entitled to give evidence about questions of genuineness and authenticity. But as I will go on to demonstrate, I hope, in this case, even with that submission ringing in this court's ears, Miss Broadley was still very cautious about the way she was expressing herself. Actually, I can go straight away to Miss Broadley's statement on that issue of authenticity. And
the reason I was pointing about the teacher is that, across the range of family proceedings, we'll all have read tens of reports from schools expressing what might be described as opinion evidence. The ability of the child. My impression is, as you say,
yes.
My perception is.
Yes. I mean, the real mischief, I suppose, is parties giving evidence of which has an expert, has an opinion character about it, without having the sufficient expertise to do so.
Yes, I think what you were saying, moving to, or what Mr. Justice MacDonald pointed out, was the difficulties that can occur, or might occur, as was identified yesterday, when the same person is a solicitor and also a guardian.
Yes.
And that is where attention might arise.
Yes. And I think leading on from that, the fact that a solicitor guardian, even one with the expertise that Miss Broadley and indeed Mr. Netto have in interviewing clients generally, as well as interviewing and representing children, have, when they come close to giving opinions that are far better given by those with social work experience. And one can easily come up with examples. A welfare recommendation. Authenticity, though, in my submission, in a statement, is evidence that is not inadmissible, either because it's expert opinion or because it's inappropriate expert opinion from a solicitor guardian. But what I wanted to go on to submit is that if there is an issue, it can be raised, and the court, in the deployment of its wide case management powers, can make consequential alternative directions. It may be appropriate for there to be a Kafkas guardian appointed to act in tandem with the solicitor. My Lord knows from our skeleton that that's what Miss Broadley and indeed myself operated under in the Riyar case, the asylum case that my Lord dealt with a couple of years ago, where in that case a Gillick competent child nonetheless, by agreement of all parties, including the left behind parent, was represented through a Kafkas guardian, the previously appointed reporting officer, who then instructed the child solicitor. And that is a model that can be deployed if there is an issue about authenticity or indeed any other issue. There may be other ways of dealing with questions of authenticity by simply having that Kafkas officer providing a report, which was canvassed in this case, and I need to deal with that in due course as well. It's unlikely for there to be a further expert instructed because of the nature of Hague Convention proceedings, them being summary. But I suppose I wouldn't rule out the possibility in a very exceptional case that there might need to be psychological evidence pursuant to a Part 25 direction, notwithstanding that these are summary procedures. But those are all matters that can be considered by the court. My Lord, I come now to the 4th of April hearing. I must come back to deal with other matters in Miss Broadley's statement, but at the 4th of April hearing, far from the parties forgetting or overlooking the issue of further involvement from Miss Callahan, the Kafkas officer, Miss Broadley instructed junior counsel, Miss Baker, to make the necessary inquiries of Kafkas, and you've seen the result in the email from Miss Doyle, and to raise the issue with the advocates. It was something also that Mrs. Justice Theis herself directed, just so my lady's clear, and I don't think there's any dispute about this. The set-aside hearing took the part of the morning. I'm not going to quarrel with 1.5 hours if that was the length. The submissions finished at around 1:05. Mrs. Justice Theis said she'd give judgment at 2 and directed the parties to consider directions on an either-or basis over the lunch and adjournment, including mediation, including questions of oral evidence, and including the need for any further involvement from Miss Callahan of Kafkas. Inquiries were made. X's case is different to the mother's case because Miss Broadley was understandably bearing in mind the caution expressed by Mr. Justice MacDonald, and I should say in parenthesis that Miss Broadley was involved in that case, as she's specified, she set out in her own witness statement. So very alive to the risks, potentially, of a solicitor guardian giving evidence that perhaps it might be said to be more in the providence of a Kafkas officer. She instructed her legal team, including me, to raise those issues. It would have been perfectly open for the father, with his very experienced leading counsel who was representing him on that occasion, to have made an application to Mrs. Justice Theis, as she had invited the father to consider at the earlier March hearing, Mr. Johns taking to the recital. Father could have made the application at the 4th of April hearing for Miss Callahan to consider the important issue of influence, genuineness of Amelia's, X's views, comparing the position in January to the position that was given to Miss Broadley, analysing what had happened, considering very carefully, if necessary, by re-interviewing X, what had been said to Miss Callahan in January, but also to Miss Broadley in March. And therefore making that application for a further report. Indeed, Miss Doyle's letter makes it perfectly clear that that could have been timetabled, even with the very tight timetable that Mrs. Justice Theis had imposed on the case. The father did not make that application. Mother was content. After some due consideration, X did not pursue a report either. Why should she? She had Miss Broadley's statements that on the face of it was not being challenged as being inappropriate or inadmissible in any way. It's right that the father reserved his position in respect of sibling separation. It's a slightly different point for the purposes of this submission. It was clear then from the timetabling that there would need to be a change in leading counsel, which is why the position as to that was reserved. Of course, I say respectfully, of course, the ultimate decision, it being a case management decision, was for Mrs. Justice Theis. And she ruled that she would not be assisted, it would not be necessary that there be further involvement from Kafkas. So there wasn't. But going back then to other points on the questions of authenticity, can I take the court to page 157 in the core bundle, which is 3 pages into Miss Broadley's first statement? And you'll notice from the first sentence straight away, Miss Broadley doesn't say, in my opinion, that Amelia's views are authentically her own. She's far more circumspect than that.
So what paragraph?
Paragraph 5, I'm sorry. Paragraph 5. I agree with Miss Callahan's assessment of X's maturity. I also agree that she does not present as having been coached. Not present as. I agree with. In fact, in my submission, on close analysis, all of this statement, in its expression of views, is suitably and appropriately circumspect. Miss Broadley knows the limit of her expertise and knows the limit of the opinion evidence that she can properly give. She is entitled to take into account questions of authenticity. I don't think there's any dispute about this when assessing X's competence to instruct. She deals with that at paragraph 7. Even then, the paragraph, for example, dealing with X's unsettled school career, Miss Broadley doesn't say did, and I'm looking 2/3 of the way through paragraph 7 on that page, but rather this may have impacted on X's ability to communicate with confidence. While the court is on that page, just very briefly at paragraph 6, the court will see a quick resume of Miss Broadley's expertise, and Milady will see references to her involvement in Ciccone and Ritchie, and indeed Riar, as I have already submitted. Then going on at the bottom of the page at paragraph 7, again introducing Miss Callahan, the Kafkas officer, who assesses her maturity commensurate to her chronological age. That's how she introduces what follows. I would broadly agree, but in my assessment I also rely upon the head teacher's view of X's maturity. She's a sophisticated maturity beyond her years. So she, again, is being very guarded, relying on others, particularly the Kafkas officer, but also the head teacher. Much can be the same about her assessment of X's identity as British, dealt with in paragraph 8. But the court, in my submission, should note the way that this statement, as indeed the second statement, is phrased. X expressed, looking over the page. X accepts. And at 9, I was able to explain to X some of the safeguards that can be put in place. That's dealing with Article 13b issues. My lady will recall that this statement was in support of an application for, this is at paragraph 1 of the statement at 155, an application for disclosure of court papers and the stay. That is made clear at the end of the statement, page 161. And Miss Broadley goes on, I wish to be able to consider with X, with the benefit of sight of all the papers, whether it is appropriate and in her best interest for an application. So, dealing head on with the duality of the role of a solicitor guardian. With all due respect to submissions to the contrary, in this type of scenario, it's inevitable that a solicitor guardian will speak with a child such as X prior to having sight of the papers. Because in Hague Convention proceedings, typically a child comes to a solicitor guardian before the court has made that young person a party. So before that person has any entitlement to seeing the case papers. It's only in unusual cases that an order for joinder is made at the very first hearing, when there isn't a problem with papers. And just for the sake of completeness, not only is that in settlement cases, but now as the practice direction sets out, a child must be joined according to the Supreme Court and according to the practice guidance, where there is a linked asylum claim running alongside the convention proceedings. It may be that in those cases the papers can be delivered to the solicitor or the solicitor guardian prior to the solicitor guardian seeing the child, but that is unusual. my lord, 162 is the second statement. Paragraph 2. Miss Broadley makes clear 4 or 5 pages, 4 or 5 lines down in preparing this second statement. I've had the benefit of reading the Kafkas report prepared by Miss Callahan, an agreed note of her oral evidence, and the statements of the parents, both of which were extremely long, which you may have seen touched on in the first judgment. My lord, Miss Broadley doesn't work against Kafkas. It's not an either-or, as some of the submissions yesterday suggested. Miss Broadley, as she did in this case, works with Kafkas, in tandem with Kafkas, very much relies on Kafkas. Ultimately, Mrs. Justice Theis wasn't making a binary choice between preferring the evidence of one witness over the evidence of another. Of course, there's the chronological difference. But that said, it was a matter for the judge to assess, to evaluate the different evidence in writing before her, having listened to the submissions of the parties, and forming the conclusions that she did. It was suggested that Kafka should have a right of reply yesterday. We don't, with respect to Ms. Kirby, understand that submission. Kafka isn't a party, and I think as my lady observed this morning, Miss Doyle had made clear what Kafka's position would be. But I repeat the submission I made earlier. If it had been a concern and had been done in proper order, it may well have been that there would have been further involvement from Miss Callahan. But that's to speculate. That's not this appeal. Just doing very briefly, paragraph 3. Miss Broadley doesn't propose to repeat what's covered in the first statement, but is very clear that nothing that she had read altered her position as to competence. And I don't think even now it's seriously argued that X did not have sufficient competence to instruct a solicitor in her own right. Maybe paragraph 4. I submit that although this might be considered to be opinion evidence, it's opinion evidence that Miss Broadley is entitled to give. Firstly, because it's within her expertise as a solicitor guardian, and secondly, because it's based on what she factually observes. And she makes very clear that it's based on X's instructions, her perception of the way those instructions were transmitted. Compelling, clear, and heartfelt, not in a churlish nor disrespectful way. I'm not sure if those are all adjectives, but there it is. A gentle and sweet sincerity. I submit without equivocation, Miss Broadley is entitled to give that evidence, even if it's opinion evidence. And no one in this case suggested that she couldn't. As an aside, towards the end of that paragraph, Miss Broadley deals with another aspect of her experience of being consulted by teenagers. She has persuaded a number of those to comply with an order for their return, successfully explaining the concept of the Hague Convention, the summary nature of it, the likelihood that the return may only cause a slight disruption, as the courts in the home country will resolve issues in relation to their welfare. Many young people who are the subject of a return order do not fully understand the process at all. Many are confused. Some have been clearly influenced by a parent. Others are simply too young to instruct me. This is not some sort of cottage industry This is, in my respectful submission, solicitor guardians providing assistance to children to make sure their voice has been heard, on the one hand, but in other cases, helping children go back in compliance with a court order. The potential scenarios are many. Miss Broadley, as a prerequisite for being appointed guardian, must have no interest in the outcome of the proceedings. And of course, she considers and acts on the real duties she has to represent her client, but also where it is within her expertise to express views about the way that a child is presenting, strength, the rationality of their objections, in this case based on her experience of her father's abusive behaviour, her missing school, and her identity of being British. Those are perfectly appropriate matters for Miss Broadley to deal with, which she then does in some detail in paragraphs 9, 13, and then 14, dealing with the stage in her life, and then 15, dealing with her time in Mauritius, 22, her experiences of England, going through to 28. I'm not going to go through and pick each individual phrase and to allocate it to a category of factual evidence, permissible expert evidence, or expert evidence beyond the remit of Miss Broadley's expertise. That never happened below. And in my respectful submission, it's not going to assist this court. Suffice to say that there is nothing inadmissible or inappropriate about the evidence that Miss Broadley gives in these two statements. I reiterate that if there had been a concern about a particular part of Miss Broadley's evidence, a particular part of whether, for example, whether Miss Broadley was entitled to give a view about authenticity, or whether she was right about that, she could have been called. Even in summary proceedings, there are exceptions to the rule or the practice that there shouldn't be oral evidence. Perfectly normal for Kafkas officers to give oral evidence. Ms. Hanson gave oral evidence in the WF case. It would have been open for Miss Broadley to give evidence in this case. No doubt, leading counsel on the 4th of April had that very much in mind, taken a view, and indeed that view was maintained, because there's been no application for there to be a challenge in the witness box to Miss Broadley's written evidence. My ladies, my lord, I've tried to deal with some of the wider points as I've gone along. Just a couple of other submissions to make. It may very well be that this court takes the view that it's not ideal to have a qualified solicitor perform the role of a solicitor guardian. It didn't cause a problem in my submission for X or Mrs. Justice Theis in this case. But in my submission, given the endorsement that that practice appears to have had from the highest court in the land, from Lord Wilson, it is a matter, respectfully, that should be left to the Rules Committee. It may well be that Hague Convention proceedings should be included in the list of proceedings in Rule 16. 6, subparagraph 2, where a GILIC competent child should be permitted to instruct a solicitor without a guardian. On the face of it, there's no distinction that can be made between, on the one hand, summary return proceedings in the inherent jurisdiction, which are specifically listed in that rule, on the one hand, and Hague Convention proceedings on the other. It is our submission that it is vital that GILIC competent children, or children with competence, capacity to instruct, should have their voice heard loudly and clearly by courts dealing with Hague Convention proceedings without being filtered through a child's guardian. That's not to say that there might be by child's guardian, I mean a Kafka's social work type guardian, or indeed any other type of guardian. There may be cases where it is appropriate, there's a particular vulnerability of a child, or for some other reason, or because the issue is so controversial that the court considers it appropriate to have extra assistance from a different type of professional. That wasn't this case, the case of X, and I would submit that it's unlikely to be a problem in most other cases. I respectfully submit that the Law Society guidance is not particularly germane and of assistance to this scenario, as I've already referred to the issue with the papers and the timing of seeing a child, but these are not public law proceedings. Welfare is not the paramount consideration, although it is the first consideration, primary consideration, but perhaps more importantly, in public law proceedings, the solicitor for a child is never acting as guardian, whereas because of the rules in this type of case in Hague Convention proceedings, a solicitor is appointed as guardian. Miss Broadley, in this case, as I would respectfully submit is good practice, told the parents at the first opportunity she had, when she had formed a preliminary view as to X's capacity, did tell the parents that she was informed, invited them to consent to an order releasing the papers, and behaved very appropriately in my submission. That is what solicitor guardians should do in this case, and in any type of Hague Convention proceedings. It's incumbent on a solicitor guardian, we would suggest, to keep under review issues such as capacity, issues as to whether there should be a welfare, typically Kafka's guardian, appointed in place of themselves as a solicitor guardian. But we emphasise that if other parties don't agree, then they're entitled to bring the matter before the court, and ultimately it is the court that controls the way that a child in Hague Convention proceedings, as indeed in any other type of proceedings, is whether or not they're joined, how they're joined, what role they should play in the proceedings. And I echo Lord Wilson in Real C, who describes how it might be appropriate for a child to take a role in proceedings. But in this case, it would have been open, as indeed it would in any other Hague Convention case, for the court to order disclosure of, for example, the attendance notes. I think, if I understand correctly, that happened in the other appeal that my lady is hearing. It was never an application made in this case, but it might be in other cases perfectly appropriate, and it needn't create problems of waiver of privilege, and I'm not going to make any further submission on that issue, other than simply saying that in an appropriate case, disclosure of attendance notes between a child and the solicitor guardian could be disclosed. May I just turn my back?
Of course.
Is there anything else? perhaps I could just take, my ladies, and this is in response to my Lord's point, to page 492 in the authorities bundle.
Which tab is
Sorry,
that?
490. What tab? Thank you.
Tab 23, I think.
Yes. So we seem to have different. Sorry, my bundle seems to have different pagination to my learned juniors.
What are we looking for?
Is it in is it CS?
Only-
There's a passage in
it's
CS?
it is tab 22, yes.
22 or 23? Are we looking at CS? Or are
No,
we
Chiconia
looking...
Ritchie.
Right,
Okay.
I
that's all right. We're in the right case now.
understand what's happening.
Paragraph?
It's I've got it at paragraph 59 at 466.
Yes, thank you. Yes, well, yes.
50,
We'll have that, thank you.
paragraph 59.
It's 59 and 60. Is where it's touched on. And then
Whether the child's voice could be adequately heard through the agency of the CAFCAS.
yes, and then there's a further passage or further section, ancillary directions at 70. Yes, it starts at 69. Thank you. Ancillary directions. The section starts at 69, but you'll see at 70 an issue arose during the course of the hearing as to whether, in circumstances where a child is joined as a party, represented by a solicitor guardian, necessary to have a report on the question of whether the child's objections are authentic, as opposed to the product of influence. It's right to observe that Mr. Justice MacDonald says quite clearly he would have liked to have an opportunity to explore the issue in more depth during submissions. And then I think the paragraph that my Lord had in mind was paragraph 72. And then leading in 70 on to 73. But he emphasised, he caveats his view at 73 without seeking to lay down any general principle or rule.
Thank you.
Unless I can assist further.
Yeah, thank you very much, Mr. Hames. Now, I think then you would probably like us to rise so that
Yes,
you can
please.
do musical chairs again.
Yes.
Thank you for your advice.
Remember, you're still live on air. You're not shouting swear.
I don't have to say that to my junior.
Yeah, I thought of something for my I think yeah. Yeah. Like just looking straight. Where
Can I give you those? Those are hard copies.
then where Henry? Henry, are you coming up here?
Um,
Great.
Yeah, or just I'll hand it to their clerks.
I think you might be able to stay there. Yeah. Where's Deirdre? Where are they? Are you here? Okay. Great. Great. Yeah, we're going to fix it. You're going first. Yeah, yeah. Okay, okay, grand. Well, why don't you take this and I'll come back in here also. Yeah, you go in there, I'll come back. Well, me and Sharon will be back. Yeah, I'll need to go a bit further. Okay. Sorry. Sorry. Whoa! Sorry, you're just trying to get this out of your way. No, I'll go in there.
Because there's only me, there's only 4 of us.
Okay. Yeah.
Why don't I'll go past Deirdre and then you can
so
sit where you are. Exactly.
Exactly,
It's a good point. I'll just go and sit between Deirdre and Henry. This is meant to stay where you are. Thank you. It saves you changing it. Mind me perching here, Henry.
Sorry. I'll stay out here so you got more room. And James gave me this morning, if you move that file,
Thank you very much.
seems wise. Here, are you both, if you're both speaking, do you want another solid as well? Are you sharing that? Or you want? Yep.
If that's all right with you.
My ladies and my lord, as you know, I appear with Mrs. Kavanagh and Mrs. Kelly on behalf of the Association of Lawyers of Children. First of all, may I say how grateful the Association is to the court for allowing the Association to intervene in these proceedings by way of written and oral submissions. In my oral submissions, which I hope I'll be able to deal with in about 30 minutes, if not less, what I would like to do is to revisit a number of points that are made in our skeleton argument, but also, having had the opportunity to observe the exchanges between the court and other advocates, perhaps to deal with some of the issues that have arisen in that context. It goes without saying, I hope, but I'll say it anyway, that the Association for Lawyers for Children invites the court and understands that the court's focus within these proceedings is very much on the effective representation of children within Hague Convention proceedings. And insofar as we make submissions, what we seek to do is to signpost certain elements of practice in other areas under the legislative scheme,
which may be of assistance to this court when considering whether guidance should be given and the nature of that guidance. In doing so, we return and draw the court's attention very much to the question of what is the most effective way for children to participate in proceedings, because that really is the question that the court is considering. And although the court has heard extensive submissions on the role of the solicitor and what the solicitor can and can't do, behind that, of course, is this question of how should a children's views, how should a children's objections in the context of Hague proceedings be properly brought to the attention of the court. We're very aware of the fact that this court will have in mind the balance that is to be struck between the protective rights of children on the one hand and the participatory rights of children on the other. In other words, recognising a child's autonomy and their entitlement to become involved appropriately in proceedings. But we commend very much to the court the need for caution, which we say is identified in a number of the authorities. And we commend very much to the court the point in principle, or the point of principle, that it's generally to a child's benefit that they have the representation of a Kafka's guardian in tandem with the child's solicitor. And even where a child parts company with the Kafka's guardian, there needs to be careful consideration as to that individual continuing in that role, and careful consideration of what the consequences are of when that does not happen. So those are the global points that we would like to make. In our skeleton argument, we deal, broadly speaking, with two issues, and I'm going to make oral submissions on both of those. The first is to look at how the question of separate representation of children within Hague Convention proceedings has developed. I know the court has looked at that right through these two appeals, but if I may, I want to retrace it a little bit just to signpost some points that we would like to draw to the court's attention. And then I'll make some submissions on the issue of assessing competence, because that is a matter that I think has occupied a considerable amount of the court's exchanges between the advocates. So starting with the question then of children's representation within proceedings, we make the point in our skeleton argument, and I'd like to revisit it, as to the emergence of this concept of the solicitor guardian within Hague Convention proceedings. And it's important and necessary, we would say, for this court to bear in mind when looking at the question of guidance, that this is a role which has developed as a pragmatic solution to a lacuna in the rules. And that really has to be the starting point of the court's analysis. So if I may just take the court very briefly through the three relevant authorities. The first, of course, is the decision of Mr. Justice Baker, as he then was, in the WF case. And the court has looked at this previously, and you'll find it at tab 21. It's at electronic bundle page 423. Now, looking at the exercise that the court was undertaking in this case, the question of the joinder of the children or the representation of the children by solicitor guardians arose as a preliminary case management issue. And in that case, Mr. Justice Baker identified the lacuna which exists from the fact that specified proceedings which allow for a child under Rule 16.6 to directly instruct the guardian, don't, of course, that rule, of course, not applying to Hague Convention proceedings. He was, of course, dealing with the position under the old rules. But he makes a number of observations which we say this court needs to bear in mind when looking at the issue of guidance. And he begins this at paragraph 24, when he looks at the submissions of the Kafka's advocate, Ms. Honeyman. Well, perhaps it might be helpful to look at the discussion as to Ms. Hanson's role. So paragraphs 21 and 22, the electronic bundle 433, and I think it's also hard copy bundle 433. And the issue there was that the child, or the children, had already met with Miss Hanson, who was their solicitor, and they had done so, as it were, outside of the legislative scheme. But there was recognition that the mechanism which provided for separate representation of children in private law proceedings didn't apply in Hague Convention proceedings. And so the way that Mr. Justice Baker put it in that case is that the irregularity, so about halfway down paragraph 22, he says the irregularity was met in this case by taking the pragmatic approach of appointing Miss Hanson as litigation friend. And then he goes on to say, but of course at that stage she'd already carried out a very considerable amount of work. Now, moving on then to paragraph 24, you'll see that Mr. Justice Baker received submissions from the solicitor representing Kafkas, or counsel representing Kafkas, as to the difficulties of taking that pragmatic approach and making some general procedural points about the joinder of children generally to proceedings, but also making some points about the benefit to a child of having a Kafkas officer or an officer of the service undertaking the investigatory role and assisting in terms of participation. And 2 points that are important to this court's consideration of guidance going forward. It's what Mr. Justice Baker says in paragraph 25. Obviously, that he didn't have the opportunity to consider this issue in any depth because it was a case management or a preliminary issue within the context of the final hearing in that case. But also at the bottom of paragraph 25, where he says, without wishing to lay down any rigid rules, it seems to me clearly preferable, where time and resources permit, for the child to be seen by the Kafkas High Court team before any decision is taken as to party status. Now, of course, I recognise this court isn't dealing with the issue of party status. This court is dealing with the issue of separate representation of children. But that, we say, is important because what Mr. Justice Baker was doing in that case was making a pragmatic decision to, as it were, close the gap or to deal with the lacuna which existed as a consequence of the rule not allowing a scheme or an approach which is available to children in public law proceedings and in private law proceedings to make that available to children in Hague Convention proceedings. It's helpful also then, very briefly...
Sorry to interrupt you.
Of course.
That is a very broad observation. But what it brings, certainly to my mind, is that there are quite a number of different issues engaged when you're considering the joinder of children in Hague proceedings and how the child's views, wishes are conveyed, whether there needs to be a guardian, so whether the rules should be changed, if somebody is appointed as solicitor and guardian, what is it appropriate or not appropriate for them to do, looking at it. So some of it is rules, some of it's quite general guidance.
Yes.
And we can see here there are quite a number of different views being expressed as to how best to approach this. And certainly, as I say, speaking for myself, I wonder whether we are best placed to give that general guidance, or whether actually a committee convened by the President and hearing from all the different parties potentially engaged, including Kafkas, because they would undoubtedly have something to say about this, and they're not represented in proceedings, would be a way forward, or what you would say about that. Because something like that, and we are not in a position to say, are we really, as a matter of guidance, it would be preferable where the time and resources permit. I mean, we might endorse that, we might, but it's a very general element. I mean, it's a specific element in a general process.
Yes. Well, Mauritius may have anticipated where I was going, but certainly one of the concerns of the ALC, which I think I hope emerges from our document, is that this process of using solicitor guardians and the role of the solicitor guardian, what the solicitor guardian does in any particular case, has evolved incrementally. It seems, without meaning to be...
In an ad hoc way.
In an ad hoc way, but also to some extent under the wire. as it were, because there's relatively little by way of reported case law. But what struck the ALC when these submissions were drafted and lodged with the court is there is a real difficulty, because there's a certain amount of case law dealing with the fact that it is permissible to fill the gap by using this device, but there's no case law, no guidance anywhere as to what that individual can and cannot do. And my Lord had a discussion with Mr. Hames and Mr. Jarman about the blurring of the lines between the role of the solicitor, the point made by Mr. Justice MacDonald, which I was going to take the court to in due course. That is a matter which greatly troubles the ALC, and no doubt it is a matter which troubles the court, but how this court resolves it is a different question, or whether this court can resolve it is a different question. What the ALC would emphasise in our submissions is it's not a satisfactory situation for children who are the subject of Hague Convention proceedings that the scheme for their direct representation would be cobbled together, as it were, between a number of different cases and good practice on the ground by solicitors. But it's a very, as my Lord says, ad hoc arrangement when compared with the very clear scheme that exists for representation under public law proceedings, specified proceedings, and private law proceedings. Now, we would invite this court, and I may get to this, I may not, you may not want me to deal with it, but we would invite this court to look carefully at, for example, the Family Justice Council guidance. And I think yesterday my Lady Justice King, in discussions with, I think it was Mr. Gratian, there was some consideration of whether this was a two-stage process, the first stage being competence, and there being perhaps a second stage. In terms of the correct way forward, we say absolutely this needs to go to the Rules Committee, and we say that if there's going to be more or wider consideration, then it is a matter for the President of the Family Division, because it involves a whole series of stakeholders, and it isn't just a question of looking at the expertise of those individuals representing children in Hague Convention proceedings. We don't doubt and commend and recognise that expertise. The question is, how do you ensure that children who are similarly situated have the same protection and the same entitlement to participate? That's the question, and that hasn't been considered. Now, whether this court is considering it in the context of this appeal is a matter for this court. And if this court is considering it, we would signpost the court to certain guidance, as I said. But it does trouble us.
Just pause there for
Yes.
a moment. Ms. Cottrell, having heard the detailed submissions over the last day and a half and read yours and indeed Reunite's submissions and your limbering up remarks, I think we have really reached the conclusion that it's not going to be appropriate for this court to give detailed general guidance about how a solicited guardian should work, if they should exist, if they shouldn't exist, what the rules should be, who we should hear from. We're very conscious we haven't got Kafkas here.
Yes.
And I think we are more and more driven to being grateful that the matters come before us because we hope that we can assist by making appropriate referrals to the right people to get this matter dealt with as a matter of urgency and deal with the appeals that we have in front of us. So on that basis, I don't think it's really very appropriate for us to ask either you or in due course Mr. Setright to go through how you would suggest we structure any guidance.
Yes.
I think there's a danger of us trespassing on what we're absolutely clear we shouldn't be doing.
Yes.
We would, of course, want to hear anything else that you think would be of assistance to us, and we will, of course, have in mind that things don't happen overnight.
Yes.
And that we just have to think about what, if any, assistance we can give to particularly childcare solicitors and CAFCAS and everyone involved in Hague proceedings to be going on with, if I can put it like that.
Yes, of course, of course. Well, my lady, may I say this, that certainly from the point of view, as I said, of the ALC, a referring of this matter to the Rules Committee and or anyone else who is best placed to deal with this is certainly something the ALC would welcome. Bearing in mind my lady's observation that things don't happen overnight and the fact that the court is dealing with this question, if I may make a few very brief submissions, which are not aimed at guidance, but perhaps
that would be most helpful, please do.
Yes, well, this court may be driven to make certain observations as to the interpretation and application of the rules, because that is a matter that is before the court. And perhaps further, there's no difficulty, we would say, in this court signposting, if I can put it that way, other assistance that is to be found, for example, from the Family Justice Guidance. And so it may be that I simply just signpost a number of
that would be most helpful. Thank you.
In terms just of the development of the case law, the only other 2 points that I wanted to make, and the court will have this, I think, from our written note, but obviously there is the decision of Mr. Justice Baker in WF and what is said there. We say also that it is relevant to look at the decision of Lord Wilson, the judgment of Lord Wilson in the LC case, and if I can particularly signpost the court to paragraph 56 of that, paragraph 50 and paragraph 51 in relation to the general issues around appointing of guardians and children joining proceedings, but also if this court is going to give assistance to judges at first instance, perhaps it is an endorsement, or endorsement is the wrong way around, isn't it? Because it's the Supreme Court. But perhaps if it's the court reiterating,
I'd endorse the Supreme Court.
Perhaps it's this court reiterating what is said by Lord Wilson in paragraph 55 as to case management, because in the exchanges between my lord and various advocates, we can see that there's a concern as to the blurring of the lines between the role of the solicitor as solicitor, in other words, receiving and acting on instructions, and the role of solicitor as guardian, whatever that may be considered to be in the context of proceedings. And Mr. Justice MacDonald, picking up on the paragraph 55 point from LC, when he comes to look at that issue in the context of the Ciccione decision, makes the very important point that where a solicitor is directly instructed by a child in Hague Convention proceedings, and the live issue in that case invariably would be the child's objections, that a solicitor would need to be very cautious indeed about stepping into evaluating authenticity. And the reference for that at the court has already been given, but it is the Ciccione decision, which is tab 22, electronic bundle page 457. And it's really paragraphs 70 through to 72, where although Mr. Justice MacDonald makes it very clear that he's not considering that issue in the case before him, he does sound a note of caution. Now, if this court reads those two cases together, if this court reads the observations of Lord Wilson at paragraph 55 as to the necessity of careful, close case management as to the role of the solicitor, but also the note of caution sounded by Mr. Justice MacDonald in the Ciccione case. In our submission, that would be of assistance, not just to solicitors taking on the role of guardian, but also to judges at first instance, being reminded of the need to very carefully consider how the child's evidence comes before the court. And one of the points that the ALC would make here is the real issue for the court to consider is the child's evidence. How does the child's evidence come before the court? And insofar as a solicitor makes a statement to the court in any proceedings where the solicitor is representing the child, the purpose of that statement is to convey the child's evidence. And where the solicitor is then drawn into other matters as to observations, as to presentation, as to the strength of feeling, those are matters that need to be approached with real caution, because there is a blurring of the line between advocating and representing a child, which is perfectly appropriate, and that is the role of the solicitor and the role for which they are trained, and expressing opinions and views about authenticity and those issues, which are very problematic.
But just picking up one, I mean, you might see in a statement the views were expressed with vehemence, and you need to include a word like that to convey what is being said. If you just do it blunt, without including words that describe what you're perceiving, it removes quite an important element of the objection, the views, the feelings. You can say vehement, can't you?
It's not my submission that the solicitor can't say that. What we say is that caution needs to be exercised as to how that evidence is brought before the court. And perhaps what it illustrates in the submissions that you've heard across these two appeals, but also the degree to which this has occupied the exchanges between the court and advocates, perhaps what it illustrates is that it does have the potential for confusion, and it points towards the benefit of a guardian continuing to have a role, or, as in private law proceedings, where a child is joined under Rule 16.6, that you have a Kafka's reporter, or if you go all the way back to the Riquet decision of Mr. Justice Munby, as he then was back in 2000, the position in that case was that an independent social worker was brought in to deal with wishes and feelings in that context, child's objections in this context, because it's the blurring of the line for the solicitor that becomes problematic. And although one has to look at that from the perspective of the solicitor, the real question is, how does that affect the participation of the child? Is it blurring the lines in terms of instructions that the child is giving to their solicitor for representation? And is there a clearer benefit to the child of having a Kafka's guardian or an officer of the service acting as a Section 7 reporter, or a similar exercise? And I suppose the point that we would emphasise is that it's difficult to see, and we haven't heard argument or seen any evidence or research that points in this direction, it's difficult to see how maintaining the role of a Kafka's guardian is to the detriment of the child. It doesn't negate the entitlement of the solicitor to file evidence on behalf of the child, or to make the sorts of observations that my Lord has indicated are appropriate. But it's really when you get into this question of evaluating authenticity or assessing authenticity that it becomes a difficult exercise for the solicitor to discharge.
I think a question, and this is why I don't think we feel we're in a position to give general guidance, is whether that needs to, the Kafkas would need to be appointed as a guardian, or whether we can follow what I would describe as the traditional model of Kafkas seeing the child maybe more than once and writing a report.
Yes.
So whether you actually need a guardian, I mean, in other cases, as has been discussed during the course of this case, the guardian is giving very broad, or undertaking a very broad welfare analysis, and that is not typically happened in this case. Settlement is broader. appreciate that. Asylum raises other difficult legal issues. But so there needs to be consideration as to whether, first, as you said, there needs to be a guardian, or whether you can have a solicitor instructed directly and continue with the conventional model of Kafka's reporting on the child's wishes, feelings, views, objections.
But there may be two issues that arise in relation to that. One issue is the, if you like, the jumping off point in Rule 16.24. If one looks at the first sentence of 16.24, it envisages that role being discharged by an officer of the service. And so the question that the court would have to consider is why should it be discharged by somebody other than an officer of the service? And that leads you into the difficult situation where there isn't a mechanism for separate representation of the child. And what the court is trying to do is to do two things within Rule 16.24 that may be broader or more complicated than 16.24 envisages. And the consequence of that is that you end up with a guardian, a solicitor discharging two roles, and that potentially is problematic if it's going to lead to this blurring of the lines, because all the ALC is concerned to convey is the importance of ensuring that if a child benefits from having an officer of the service, whether that is as guardian or Section 7 reporter or whatever, but whether if the child benefits from having an officer of the service, that the child shouldn't be deprived of that in order to allow the child to directly instruct a solicitor. And I hope that makes sense. And what is happening, perhaps, is that there's a leapfrogging over that exercise to allow the child to directly instruct a solicitor without perhaps having the opportunity to consider the full consequences of that. One would hope that there would not be circumstances, but this happens in specified proceedings, where the view of the guardian and the view of the child as conveyed through their solicitor are at odds. I mean, that happens, and that's something that the court has to resolve.
Can you remind me which rule is it says in what proceedings a guardian is not necessary?
I think it is, forgive me, 16.6, but we deal with it in our skeleton argument. So
You do, I just couldn't.
bear with me.
16.6.
So it's 16.6, and we deal with it in our skeleton argument from paragraph 18 through to, I think it is paragraph 26.
Yes.
So the submission really that we would make about that is obviously, while the court doesn't wish to give guidance, judges at first instance may find a judgment on this issue without observations from this court to be somewhat confusing. It may be helpful if the court is able, perhaps, to make some observations.
Delicately put.
The only other matters then that we would flag up is in relation to the competency exercise, and I know that again the court isn't minded to give guidance, but in relation to the competency exercise, there are just a couple of points we would make in relation to that. What emerges from the CS decision of Mr. Justice Williams, the re-W decision of this court, the decision of Lady Justice Black, and the Family Justice Council guidance. And we'd invite the court to have a nod, as it were, to all of those three, the two cases and the guidance itself. But what emerges from those are a few points which are important to emphasise. One is that the competency exercise, which to some extent is similar to that which is undertaken by a solicitor in Hague Convention proceedings, what a solicitor is doing in that exercise is looking at the question of whether the child is competent to instruct them. And that means really that the solicitor is looking at the question of whether they should accept instructions from the child. And that's all very helpfully set out in the Family Justice Council guidance. And it's very, very clear in that what it is. If one looks at the guidance, it's at tab 34 of your authorities bundle, pages 6, 8, 7 onwards. Bearing in mind, of course, the role of the Family Justice Council, it's a non-statutory body, but it is an advisory body. And if one looks at the first paragraph, the aim of the guidance is to provide some consistency of approach That's very much the submission that we make to this court. The consistency of approach across different parts of the legislative schemes is fundamental. And then the second paragraph, the assessment of whether the child is competent or sufficient understanding to conduct proceedings has to be undertaken by a solicitor before taking instructions from the child. There's some very helpful paragraphs there as to principles about the child directly instructing the solicitor. You can see that in paragraph 3 in private law proceedings. And you'll see there a distinction between the role of the guardian in private law proceedings to conduct the proceedings on behalf of the child. You'll also see, importantly, and we've seen it even in this case from very experienced advocates, that there's a difference between capacity and competence. And I know that this court knows that, but there's a benefit perhaps to reiterating that, because the terms are sometimes used interchangeably, and that's the point that is made in paragraph 5. Further down at paragraph 14, there are fundamental principles that the Family Justice Council identifies when considering whether to take instructions.
Sorry, which paragraph?
Paragraph 14. And the utility, of course, of that is that that is directed at the solicitor, when the solicitor is considering whether they should take instructions. And it may assist a solicitor in Hague Convention proceedings to consider whether it's appropriate for them to take on the dual roles, as it's been phrased by others. Those principles are extremely helpful. And then the factors for assessment, which are set out in paragraph 15, all very clearly set out what is, in effect, a checklist. And then you can see at paragraph 16, the factors, each of them inform the decision about accepting instructions. And then at paragraph 17, there may be several factors that might give a solicitor cause to question the competence of a young person, regardless of their age. And that then goes in at paragraphs 18 and 19 to deal with this issue of when the solicitor's decision as to competence either has to be reviewed by the court, or the solicitor themselves may take the view that they need expert evidence. And then you'll see at paragraph 20, and in my submission this aligns itself very nicely, if I may say so, with the observations of Lord Wilson at paragraph 55 of the LC case, the exercise that the solicitor has to undertake, which may assist the court in terms of case management. So it isn't just a question of the child being competent, it's what happens then subsequently. Do they see papers? How do they give instructions? How do we bring their evidence before the court? And the circumstance in which a child might give evidence. The solicitor has to consider all of that before, of course, the court has to consider it as a case management exercise. And then there's a checklist for assessment, very helpfully included at the end of the Family Justice Council guidance. Now, it's clear from that guidance it is recent. It's dated April 2022. It follows on from REW. It follows on from the decision of Mr. Justice Williams, and so it is enormously helpful to solicitors who are dealing with this issue on the ground. And then lastly, the point that we would make in terms of the, as it were, tooling up of solicitors to ensure that they have not just the expertise in Hague Convention proceedings, but also in representing children, that there is a benefit to solicitors having panel accreditation. This court obviously can't say anything about that, but it may be an observation that the court wishes to make as to the fact that in specified proceedings, solicitors do have panel accreditation. That has to be renewed every 3 years. They have to have training as to how they carry out their functions within the proceedings generally, but there is a specific focus within that on how to represent children, how to take their instructions, how to convey their evidence, and so on. All of those matters we recognise signpost towards a committee looking at these issues, but they are issues that arise in the context of other proceedings, and certainly the Family Justice Council guidance is something we would invite this court to signpost for both courts and solicitors dealing with these issues. I think those are the points I wanted to make. May I just check with Ms. Kavanagh and with those sitting behind me as to whether there was anything further? Thank you very much.
Thank you very much. Mr. Setright, it's 5-1. Do you
just beyond, my lady.
In those circumstances, shall we adjourn then till 2 o'clock?
I'd be grateful, but I probably won't take the half hour the court kindly allotted, as I've been listening.
Yes, well, thank you for that indication, and then we'll move on after that to replies. Thank you very much. 2 o'clock, please.
Court rise is open.
And